97% of federal criminal convictions result from guilty pleas. 94% of state convictions. The American trial, the cornerstone of the Sixth Amendment, is now the exception. The plea bargain is the system. Most Americans have no idea. The mathematics of plea bargaining operates on expected value. A defendant faces a potential 20-year sentence at trial. The prosecutor offers 5 years for a guilty plea. The problem is the trial penalty is real. Studies document that defendants who exercise their Sixth Amendment right to trial and lose receive sentences 2 to 3 times longer than those who accept identical pleas. The Constitution guarantees the right to trial. This creates a coercive dynamic that the Supreme Court has acknowledged, but declined to eliminate. Prosecutors know that the threat of trial penalty is the most powerful tool they have. The offer of a plea is not generosity. The plea bargain emerged as a formal institution after the Civil War as caseloads overwhelmed courts. By the mid-20th century it had become dominant. The Supreme Court blessed it in Brady v. In North Carolina v. Alford in 1970, the Supreme Court upheld the right of a defendant to plead guilty, while simultaneously maintaining actual innocence. The Alford plea allows a defendant to accept punishment without admitting guilt. It is used in most American jurisdictions. The National Registry of Exonerations has documented over 3,400 cases since 1989 where people convicted of crimes they did not commit were later exonerated. Approximately 20% of those exonerations involved defendants who had pleaded guilty to crimes they did not commit. In Missouri v. Frye and Lafler v. Cooper in 2012, the Supreme Court held that defendants have a constitutional right to effective assistance of counsel during plea negotiations. A bad plea deal driven by incompetent advice constitutes a Sixth Amendment violation.